On June 18, 2024, President Biden, in a bid to promote family unity, introduced a new program to help undocumented immigrants who entered the U.S. unlawfully to legalize their status in the United States. This program, Parole in Place, will let them stay in the U.S. to get their green cards without needing to go back to their country. Two groups of people would benefit from this program. 1. Those married to U.S. citizens, and 2. Stepchildren of U.S. citizens. If approved, these individuals can then apply for a 3-year work permit, a green card or permanent residency without leaving the U.S., and they could also apply for U.S. citizenship. To be eligible for this discretionary grant, non-citizen spouses and stepchildren need to meet certain criteria. For spouses of U.S. citizens, they must have been continuously physically present in the United States since at least June 17, 2014 through the date of filing the Parole in Place request. They must have a legally valid marriage to a U.S. citizen on or before June 17, 2024. They must have no disqualifying criminal history and submit biometrics, undergo required background checks. For stepchildren of U.S. citizens, they must have a parent who entered into a legally valid marriage with a U.S. citizen on or before June 17, 2024 and before child turned 18 years. They must have been continuously physically present in the United States since at least June 17, 2024 through date of filing. They must have no disqualifying criminal history and submit biometrics, undergo required background checks. Starting August 19, 2024, USCIS began accepting and processing applications for this program. To apply for this benefit of Parole in Place, the spouse or stepchild of a U.S. citizen must each submit Form I-131F. The process is done online with the appropriate fee of $580. Requesters must submit the required evidence establishing eligibility. Required documentation includes the following: proof of identity, proof of manner of entry into the U.S., evidence establishing their continuous physical presence since at least June 17, 2014 or June 17, 2024 depending on basis for eligibility, evidence of qualifying relationship to a U.S. citizen, evidence of positive factors for a favorable discretionary analysis. On August 23, 2024, 16 states sued the Department of Homeland Security over the new U.S. immigration reform program because they believe the government's actions and the new program are not in line with law. On August 26, 2024, a judge in Texas stopped the program for 14 days. While applications can still be sent to USCIS, no approvals can be given during this time. The program's future is uncertain, and it is unclear whether it will be discontinued or continued. While we can speculate, no one knows for sure. If you would like to apply for this benefit, it is best to consult with a U.S. immigration attorney to determine you are eligible and if applying would be beneficial for you. We are here to help. We can help you understand your legal options and make an informed decision. Please call, text, or email us at